Well, I can confirm that during the adjournment, Mr. Marondeza spoke with the authorities at the Venture Correctional Facilities, and basically they are aware of the court's directives in this regard for the continuation. He can confirm perhaps if I have left anything out, but I believe your instructions, my lord, or directions were carried out to the letter, my lord.
No, they were carried out, Your Lordship.
Right. So we're safe to continue until we finish?
Yes, my lord. That means I'm now free to take as long as I want.
No.
My lord, the submission that I make, my lord, is that in any event, the purpose of the bail conditions is also to add to the elimination of the risk, or to allay the fears of the risk of interference, my lord. And therefore, the conditions that the court may grant, if we are successful in our application for bail, my lord, they will go a long way towards restricting or taking into account the fears that any other party, particularly the state, may have, my lord, pertaining to the bail conditions. But I submit, my lord, and I'm saying this without abandoning the ones that I proposed in the beginning, that I say when I look at them, they are very sufficient, my lord. They will take into consideration all those factors. My lord, I then say, in this instance, the risk factors including those linked with the interest of the public in administration of justice. I know there is often a very long debate about what this actually means. For me, my lord, it remains very clear. The interest of justice or administration of justice can only center on 2 or 3 pillars. That is that there will not be any interference, that the accused will attend trial, and that the accused will also respect the investigations of the state as well as the witnesses. And therefore, those being considered fairly, my lord, I submit that the applicant is a good candidate to be admitted to bail, my lord. I say this, my lord, in conclusion of my initial submissions in chief, that the trial date, and this is a fact, is still not yet in sight. We do not know when the trial itself will commence. Importantly, we once again reiterate to the attention of the Honorable Court the fact that towards the conclusion of his testimony, and that was when he was testifying in redirect, Mr. Kayengela testified that the state has lined up over 300 witnesses for the main criminal trial. We say, having looked at the history of our jurisprudence, my lord, and the experiences of our courts, we have said that history and experience surely points to a very lengthy trial that will take possibly a lot of years when regard is held to the previous cases where a lot of witnesses were also similarly lined up by the state. And therefore we say it is only fair that the fourth applicant should be granted bail, my lord, pending final determination of the matter. We submit that the applicant has met the requirements for the Honorable Court to exercise his discretion and to grant him the bail in this matter. Wherefore we pray that the applicant be granted bail, incorporating the conditions proposed by the fourth applicant, and such other additional ones as the court in its absolute discretion may grant, my lord. Those are our submissions, my lord. Unless if there are further questions, those are my submissions in chief, my lord. As it pleases, my lord.
Thank you, Your Lordship. We have also provided extensive heads of arguments in this particular case. I'm not going to regurgitate everything that is written in the heads of arguments. I'll just highlight the main points that have been dealt with before court today. First and foremost, Your Lordship, just to start off with the Atchison judgment.
You'll just have to speak up a little bit louder.
As it plays the court, Your Lordship. I just wanted to start off with the Atchison judgment that was referred to earlier on. We've dealt with that in paragraph 35 of our heads of arguments, where in the case of Charlotte Helena Botha made reference to the Atchison judgment. If the court will just bear with me. It appears that is not the citation I'm looking for, Your Lordship. It was also quoted on another page in the heads of arguments. Okay, Your Lordship, it is there in the heads of arguments, where I do not have the exact paragraph now. There are about 60-something pages of our heads. But the law as it stands currently, as found in the Charlotte Helena Botha case, is that the Acheson matter did not take into consideration, it's indicated in paragraph 157 of our heads of arguments. In instance what the court said there, was that this matter did not deal with the implications of the amendment of Section 61 of the Criminal Procedure Act. And in instance, the inquiry under Section 61 is now much wider than it used to be. So the additional factors which had to be taken into consideration, which had not been considered in the Acheson judgment, consist of public interest and interest of the administration of justice. We've extensively dealt with the issue of public interest in the heads of arguments. I'm not going to repeat what has been cited therein, but we will deal with the issue of the interest of the administration of justice, which has been dealt with before court today. Your Lordship, I just want to highlight that when dealing with the interest of the administration of justice, there are several factors that have to be taken in consideration so far as that is concerned. The issues of absconding, those also are applicable when considering the interest of the administration of justice. Taking into consideration that should an accused person be granted bail and abscond, that will evidently affect the administration of justice, taking into consideration that the trial itself will not be able to proceed. The same applies should an applicant be released on bail and interfere with the case or with witnesses. That is also going to be prejudicial to the administration of justice itself, as there will be no fair trial in that particular matter. I think as a starting point, I want to refer this court to paragraph 16 of the state's heads, which were referred to earlier on, in relation to the $4.1 million that was paid to Tundavala. Has indicated in the heads of arguments, it's not only information from Norway, there are also documents from Norway. That was the evidence of the investigating officer. His evidence was that they have trouble acquiring evidence from Dubai. But the rest of the countries where requests have been made, they've been cooperative. These funds were not paid from Dubai, they were paid from Norway. So the evidence of the source of the payments to Tundavala, that is available. We also have evidence which is available with regard to the invoices which were made for these payments. We've also produced before this court payment receipts from the DNB Bank, which are also before this court. There's a witness statement in relation to these payments as well. So at the end of the day, it's not a matter that there is no evidence that payments were in actual fact made to an entity in Dubai. That evidence is in existence and it is there. So the only evidence that is outstanding so far is the evidence from Dubai where the funds were received. When dealing with the interests of the administration of justice, and in particular, the likelihood of interfering with witnesses, all the state's case has raised as one of the objections in this particular case.
Mr. Lutubeti?
Yes, Your Lordship.
The constitutional values, particularly the right to be presumed innocent until proven guilty, and the right to liberty.
And the right to?
Liberty.
Yeah.
27 months, and the person is not found guilty. And how long do you still want to keep that person? And how fair is it? If it's not fair, is it in the interest of the administration of justice?
As it plays a court. Insofar as the time period is concerned that they've been in custody, this has been raised in the highest of arguments as well, that the trial has not taken place within a reasonable time, and the accused persons are presumed innocent until proven guilty. But insofar as the constitutional values are concerned, there's case law to the effect that when citing the Constitution, parties should not be selective as to which constitutional provisions are cited. They should, in fact, take into consideration all the constitutional provisions. And they should take into consideration also the interests of the state in ensuring that there is a fair trial, in particular cases where the accused persons, such as the case before court, have interfered with witnesses, that releasing those persons on bail will result in the trial not being fair. We appreciate the time period that is indicated by the court, that there has been some time that has passed and this trial has not yet started. But when considering the delay of the matter, there are several factors that have to be taken into consideration. The nature of the case is also one important factor that has to be taken into consideration. As in this particular case, we are not dealing with a simple theft case where someone stole a chocolate from ShopRite. We are dealing with a very complex case involving a syndicate. And we know that this particular case involved cross-border investigations, as the investigating officer testified. And taking into consideration the complexity of this matter, Your Lordship, in my opinion, the investigations were done in record time. Taking into consideration that this matter, at this stage where it is, it's in nature of fact ready for trial. Disclosure has been made. We are ready to proceed with this matter. So, where the case stands now at the moment...
You are ready, but it's not proceeding.
Yes. Because when it comes to fair trial, the court does not only consider the interests of the state, the court has to consider the interests of the accused persons. So if the accused persons are causing a delay themselves, that has to be taken into consideration. They may have their own reasons as to why...
Is there evidence before me that the applicants in this matter are the cause of the delays for this trial not to have commenced?
And I think that is where the applicants themselves have a problem in this case, because the applicants have an onus. And if they come before this court and they inform this court that this trial has not taken place within a reasonable time, then it is them who should put facts before court to indicate, well, this trial has not taken place within a reasonable time because of these particular reasons. And in considering whether or not a trial is taking place within a reasonable time, it's not only the time period that is considered. There are other factors that will be taken into consideration. The time period that has been custody is, in nature of fact, just one of the factors that have to be taken into consideration. The other factors, such as, have the accused persons asserted their rights before? That is also one factor that has to be taken into consideration. Have they objected to postponements before? Have they applied for bail before to be released on bail? Those are all factors, and we know from the applicants who are before court, it's in nature of fact just one applicant who has asserted his right to bail. The others have not done so during this time period. There are factors that have to be taken into consideration, such as the prejudice, trial prejudice, which has been occasioned by this delay. That is not before court. So if there's this complaint that this trial has not taken place within a reasonable time, they should place sufficient evidence before this court to demonstrate that, well, indeed, this time is unreasonable because of all these facts that we've highlighted before court. That is not before this court. So at the end of the day, they have not discharged that onus to show this court that this trial has, in nature of fact, not taken place within a reasonable time. And of course, Your Lordship, when it comes to the issue of bail, the issue of bail is not just a once-off issue. It's an issue that is considered even after the trial has started. So I know if we have to look at when might this trial start and so on and so forth, that at the end of the day will just be speculation. Even if we say, okay, we'll start now, we start next year, it's speculation. We don't have those facts before us. But at the end of the day, if there's going to be a delay in future in finalizing this matter, nothing precludes any of the applicants to come back before the trial court and inform the court that, look, this trial really has not taken place within a reasonable time at this stage, and we should be released. And we say that this trial has not taken place within a reasonable time because of these reasons. And at this stage, Your Lordship, there are no reasons placed before court for them to illustrate that this trial has not taken place within a reasonable time. Is there anything else that the court wants me to address on that issue?
I've just asked the question. How fair is it? And if it's not fair, is it in the interest of justice and to keep that status quo? If it's not fair.
Of keeping the accused persons in custody before the trial commences.
Yes.
In this particular case, it is in nature of fact fair, and it is in nature of fact in the interest of the administration of justice. Taking into consideration the risks and likelihoods that have been pointed out by the state in this particular matter, we know that there's evidence of the accused persons interfering with witnesses. There's evidence of accused persons.
Which evidence is that?
The statements in the docket. Okay, I can give examples, Your Lordship. Maybe.
No. You see, in this case,
Yes.
it's not a matter of examples. It's a matter of saying, applicant number 1 interfered here and here and here and here and there. Applicant number 2 interfered on this and this and this occasion. Applicant number... I can't judge and determine the inquiry on the basis of examples. I need to determine with respect to the conduct of a specific applicant before me.
Yes, Your Lordship. I think I just wanted to complete the sentence by saying, let me give an example of what they've done. Maybe before I go there, so that there's context.
Maybe go, what has applicant 1 done? What has applicant 2 done? What has applicant 3 done? What has applicant 4 done? And so that we know what it is that the state anchors its opposition to the bail on.
Yes, Your Lordship. I just wanted to provide context to that with regard to the fairness question that the court has posed with reference just to a judgment that I quoted in the haste of arguments. This is the matter of State versus Timotheus. It said paragraph 146.
Timotheus?
Timotheus.
Is it in your haste of argument?
Yes, Your Lordship. Paragraph 146, page 45. Because in instance, what happened in that particular case, the applicant had bribed a police officer with a $300 to be handed a docket. And what the court said in that particular case is of utmost importance. In dealing with Article 12, this is with regard to the right to a fair trial. The court held that there shall be no fair trial as anticipated by Article 12 of the Namibian Constitution, or possibly no trial at all, if a situation is allowed to develop whereby the accused interferes with state witnesses or police investigations, if a reasonable possibility exists that this might be the case, it will be in the best interest of the administration of justice then not to take the risk and allow such an accused out on bail, even where it is shown he will likely not abscond. I think just by way with this in mind, to give examples in this particular case, we have the second applicant, Mr. James Ueitele, in the matter before court. And evidence has been laid that he has a pending case involving bribery and obstructing the course of justice, where it is alleged he acted with co-accused persons in attempting to bribe members of the Anti-Corruption Commission. And it is alleged that there was an offer to pay them 250,000 Namibian dollars so that they can release exhibits, and in particular bank cards, for entities which stand as accused persons in this particular case, including the entities of the third applicant, Tuafika. And this is a pending case before court, and it has been presented before this honorable court that someone has in actual fact been convicted for obstructing or attempting to obstruct the course of justice in the matter where the second applicant is charged. So there is that evidence before court insofar as the second applicant is concerned. And to go further, Your Lordship, there was also information that was presented before this court in relation to a document that was retrieved from the second applicant's phone. And what was contained in this document is that he was hatching a plan to manufacture documents in order to justify the payment of the 75% that was paid to Ndavala Hayes is being alleged in this particular matter. And insofar as the first applicant is concerned, maybe if I go to the first applicant, the second applicant, we know from those communications that he spoke about manufacturing that evidence. So we know that there is something at least against him where he wants to interfere with this particular case. And it doesn't matter even if witnesses have been given statements in this case. It doesn't matter even if exhibits have been collected, because from the conduct of the first applicant, from the second applicant, Mr. James Atwilipi, it shows that they do not care, even if you are a witness who is giving a statement, they do not care, even if you've arrested them in this particular case. If they want to get to you, they'll get to you. If they have the audacity to try to bribe the members of the Anti-Corruption Commission, what is a witness to them? Nothing prevents them from approaching a witness and attempt to influence their evidence as well. Insofar as the first applicant, Mr. Shangala, is concerned, Your Lordship, from the indictment that has been submitted before this court, he also faces a count of obstructing or attempting to defeat or obstruct the course of justice. Now, in instance, the allegations against him there is that he tried to obstruct the course of justice by instructing another person to remove documents from his house which are relevant in the matter before court. That in itself is also a very serious allegation, showing that he is also capable of interfering in this case. Apart from that, Your Lordship, we also have the fourth applicant. We also have the fourth applicant in this particular case. I think this has extensively been dealt with regard to the Novadam group of companies and the agreement that he wanted them to sign. And we know that these allegations, Your Lordship, they cannot be mere allegations. In actual fact, we heard from the evidence of the investigating officer in this particular case that we know from the statement of Mr. Kamano, he speaks about that interference of being requested to sign the agreement. And from what we have on his statement, the investigator also has testified that in actual fact, it was confirmed that the payment requested for was made to his lawyer in this particular case. So it's not just a mere allegations that he had requested for a certain sum of money to be paid to his lawyer. The investigator also confirmed that, yes, there is natural fact confirmation that that payment was made. So that somewhat corroborates his version that there was a request from the applicant that he should pay a certain amount of money to the legal practitioner. And I just want to point out that insofar as that is concerned...
I hope you are not trying to persuade me to try and make findings.
No, Your Lordship. It's just to indicate that there is in actual fact an interference. And what is said in the statements is something that can be believed. That is why I'm referring to the evidence of the investigating officer, just to illustrate to the court that, well, I don't expect this court to make any finding about payments. It's just to illustrate that, to a certain extent, this is supported that he had requested for funds from this particular witness. That is all that is there. But I don't expect the court to make a finding with regard to any payments.
Yeah, why I said that is when you come up with corroboration, issues of corroboration, yes.
Yes, Your Lordship. And I just want to highlight here that in this statement, there's no indication of money being borrowed. It's a request for money to be paid. There's nothing about borrowing money. So it appears that these funds which were paid, it was paid without any expectation of it being returned.
Okay, 5, 6, it's 3, 5, 3, 5, and 6.
So far, I've dealt with 1, 2, and
You have dealt with
4.
1, 2, 4, and 4.
Yes, Your Lordship. When it comes to the fifth applicant, Mr. Shudifonya, that has also somewhat been canvassed by their legal practitioner in relation to Mr. Oti that was referred to. I think with his interference with Mr. Kamano, Your Lordship, I just want to point out that Mr. Shudifonya had testified in this court that during 2019, and it was earlier on, he had been interviewed by the members of the ACC. That evidence is before court. So it was prior to him contacting this witness, Kamano. He had been interviewed by members of the ACC. So he knew about the allegations in this matter. And he knew himself what he was doing insofar as the allegations are concerned. Even if the ACC might not have had certain information at that stage, he himself knew what was happening with all these witnesses. And from what we have before court in that statement is that he also contacted this particular potential witness at the time. And he was also making arrangements to meet this particular witness. And he was making arrangements for payments to be made on behalf of his co-applicant, Mr. Nipunya. Dealt with the issues of interference with potential witnesses in the heads of arguments, Your Lordship. I've referred to the matter of Matali versus the state. I don't think there's a need to regurgitate that. It's already in the heads of arguments. Now, the third applicant, this is Mr. Pius Matelulo. When taking into consideration this matter, Your Lordship, and when dealing with the issue of interference, we are, insofar as this case is concerned, I don't want to say fortunate because any kind of interference is unfortunate, but it's more unfortunate for the applicants when they've actually interfered and they bring a bail application, because now there's actual evidence that they have interfered before and they will interfere when they are released. But when dealing with a bail application, on the issue of interference, the court is not so much concerned with whether or not they've interfered. That is important, of course, when the court has to consider the likelihood of interference, because it shows their conduct that, yes, these ones, they're going to interfere. They've done it when they were in custody. So really, if they can still do it well in custody, the bail conditions will not assist. When they're out on bail, it will be easier for them to even interfere when being in custody does not prevent them from interfering, when that should even be much more difficult. They're not supposed to have communication devices and so on and so forth. So while they're out on bail, it will be easier for them to interfere. But what I want to point out with the third applicant, that what the court has to consider is the likelihood of the applicant interfering. That is what is before court. And in considering the likelihood of interference, there are several factors that the court has to take into consideration. And one of these very important factors is that, insofar as this case is concerned, we are dealing with a syndicate. And this syndicate operated has won. We know from the evidence before court that when Mr. James Hatukuilipi, in the case that he's facing, the allegations that he sent someone to bribe the members of the ACC to retrieve cards for the banks, including cards for Otuafika, wherein the third applicant has an interest. We know that evidence is before court. And we know from the evidence before court that Otuafika really was being run by James to a certain extent. Because we heard from Mr. Othniel Shidufonia that as he was allegedly getting loans from Otuafika, he was dealing with James. He thought James is the person running this entity, although he signed the contracts with Pius Matelolo. So what we do know is that Pius was part and parcel of this syndicate. And we know that he was taking instructions from the second applicant. We know from what has been placed before court that his former partner at some stage had, I don't expect a finding of this, but I just want to illustrate that his former partner at some stage had asked him about 2 million that was paid into Otuafika, and he said it was James' money. So we know that he's acting on instructions of James. And we know from what we heard before court that Mr. James Hatukuilipi is capable of sending people loyal to him to interfere with this matter. So is there a likelihood that Mr. Matelolo will interfere? That likelihood, taking into consideration all the surrounding circumstances, Your Lordship, I respectfully submit it's there. And if the court takes into consideration that when the person was sent to interfere with the ACC, there were cards also from Mr. Matelolo which were being requested. No, really, as a loyal subject, Mr. Matelolo is likely to interfere as well in this particular case. When dealing with the last, I think that should be the fifth applicant, Mr. What's your client's name? Mr. Mapopi. The same consideration here apply. Because the court is not concerned so much as with whether or not this person has interfered before. But is there a likelihood that Mr. Mapopi will interfere with investigations? That is the question before court. And if the court takes in consideration what has been placed before this honorable court, that from what we have, Mr. Mapopi was working very closely with Mr. Mike Nyipunya. We know from what is before court that at some stage, he was even receiving instructions from Mike Nyipunya. If Mike Nyipunya tells him that, okay, write an invoice to Novanam, he will do that, write an invoice to Novanam on Wanakadu's letterhead. So we know that he was taking instructions from Mr. Nyipunya. We also know that Jaco was in actual fact we also know from what has been placed before court that Jaco itself was the name reservation for Jaco. That was done by Mr. Nyipunya. We've dealt with the hidden interest that Mr. Nyipunya had in Jaco. We know from what we heard before court that Mike, some of his assets in this particular case were bought by Wanakadu, where the applicant himself has an interest. And he was requested to purchase assets on his behalf, which he did in this particular case. As indicated, Your Lordship, he is part and parcel of this syndicate. So whatever action that he takes to interfere with this matter, that is going to have an impact itself on the administration of justice, because at the end of the day, that is going to have an impact on the entire case. So it doesn't matter which witness is going to be interfered with by Mr. Mapopi if he's released. That in itself affects the entire case, because we are dealing with a syndicate here. So any interference that benefits him will benefit his co-accused. Nothing prevents him from taking instructions to approach other witnesses, as Mr. Othniel was also instructed in this particular matter. Your Lordship, on that basis, I respectfully submitted that in itself it will not be in the interest of the administration of justice to release the applicants on bail, because of the actual interference that has been involved and the likelihood of interfering in this matter as well. Your Lordship, I just also want to highlight that Mr. Ngipunya's bail application is a bail application. There is a bail application on new facts that is before court.
Yes, you have heard the exchange I had with Mr. Patela.
Yes, Your Lordship.
On the new facts.
Yes, Your Lordship. With regard to the binding nature of the decision. Yes, Your Lordship. Has the court pointed out that there was a decision for the Magistrates Court, which was appealed against. There was a decision from a two-bench High Court, which confirmed the Magistrates Court decision. When dealing with a bail application on new facts, that decision in the High Court itself has not been appealed against to the Supreme Court for them to challenge the correctness of the decision itself. So the correctness of the decision itself, in actual fact, stands. That is not an issue before this Honorable Court, that decision should be set aside, because it's not for this court, in actual fact, to set aside that decision. When dealing with a bail application on new facts, what has to be considered is simply, do the new facts change the basis on which bail was denied, or are they related? Are they related and change the basis on which bail was denied? That is what the court has to consider. But that is not considered in isolation. That is considered with the facts that were placed before the court of quo. And that has to be considered with regard to the judgment that was delivered by that court. So the court has to consider the judgment in its totality and consider the grounds on which bail was denied. And then at the end of the day, the court has to consider the new facts which has been presented before this court. Do they change the basis on which bail was denied? If not, then it still remains bail is denied. I think just to give an example of this, it's, for example, in a murder case.
In the?
Murder case, a case of murder. A person has been denied bail because there's a strong case against him. There's evidence against that person. Bail is denied, even by the High Court. New facts arises, and the new facts simply being that, no, look, there's this person who's admitting that he's the one who killed. It was not me. And there are witnesses to corroborate this version. It was not me. I'm not the killer. So that would be a new fact. And now if the court has to consider bail in that context, where the court had made an earlier finding that it's a serious offense, there's a strong case against you, and now this new fact has arisen, that will be something the court has to consider in determining whether or not it is a new fact that changes the basis on which bail was denied. And in this particular case, Your Lordship, insofar as Mr. Ngipunya is concerned, there is no new fact. What he has placed insofar as the Fishrot is concerned is in instance, what he placed before this court is in instance what he has placed before the Magistrates Court. Nothing new came out of that. Nothing new came out of his defense. We just know the additional charges which were leveled against him. Your Lordship, I do not want to waste this court's time. We've provided substantive heads of argument on all the issues which were raised during the bail application. Unless there's anything else that the court wants me to address it on, I respectfully submit and request for this Honorable Court to dismiss the applications of the applicants, Your Lordship.
You haven't talked about, I was going the complaint.
Oh yes, my colleague has just reminded me of one matter that I've omitted to highlight to the court. It is also forms part of the heads of arguments. Your Lordship, Mr. Shangala, the second applicant in this particular case. We've made reference to that amount of 4.1 million, which was paid to an entity called Tundabale Investments in Dubai, where the second applicant has an interest. And we've heard from the evidence of the investigating officer in this particular case that there were cell phones which were retrieved at the correctional facility. And one of the cell phones was retrieved from Mr. Shangala, the second applicant. Now, the information of relevance that was retrieved from the second applicant's phone was that he was busy researching or searching on issues of extradition from UAE and extradition from Dubai. And we know from the evidence which has not been disputed before court that in actual fact there is an amount of 4.1 million that was paid to Tundavala. We know the background of the second applicant. He has a legal background. He worked at the Law Reform and Development Commission. He worked as the Attorney General of the Republic of Namibia. He was the minister, in actual fact, at the Ministry of Justice. So this person has legal knowledge. And it is a common fact that we don't have any extradition treaties with the UAE when we're even struggling to obtain just documents from the UAE. So we know that if a person leaves and goes to the UAE, it will be impossible to get that person back. But what I want to highlight to this particular court is that even the explanation that was provided in cross-examination, although that is not evidence, that he was looking at some documents which are relevant because of allegations regarding what happened to Dubai, what happened in Dubai. When one deals with extradition, extradition is something that is very particular. It's when you request a person from another country to come and stand trial in the requesting state or to come and be sentenced in the requesting state. That is extradition. It has nothing to do with documents and what. It has to do with the person being brought to stand trial or to be sentenced. And in this particular case, Your Lordship, when we have a person with legal knowledge who's doing research on extradition in a country where it is alleged that there are funds, proceeds of crime in Namibia, well, they can easily abscond and go and start a comfortable life there. We know that Mr. Hatugilipe as well, from the passport that was presented before court, that he's an investor in that particular country, but he does not disclose this information or the nature of the investment that is there. That is not before this court. And he has the onus to discharge that he was not going to abscond, but that has not been placed before this honorable court. At the end of the day, Your Lordship, we also dealt with the issues of Tundavala Investment Limited. We know from the documents before court that there's a registered office there. There's property where it is located. But that has not been disclosed by the applicant. Neither has indicated to this particular court that who owns that property. Is it him? Is it someone else? We don't know. And that is crucial information that should have been.
Mr. Soni put it very well. To punish a person for exercising their constitutional right, because the Constitution says they have a right to remain silent. How does the right to remain silent imply interference?
No, it's not a punishment. If a person wants to exercise their right to remain silent, they can do so. In actual fact, a person can come before court and says, I intend to bring a bail application. They get into the dock. First question, how old are you? What's your name? Said, no, I choose to remain silent. And the person chooses to remain silent throughout the whole bail application. At the end of the day, there will be consequences to that because the person has chose to remain silent. But when we are dealing with this issue of remaining silent, obviously there can be legal implications attached to that. To give an example, if the state has laid evidence in a criminal trial, at the time of the discharge of Section 174, if that is refused, the accused person also has an option. It's their constitutional right. They can decide, well, I'm remaining silent, I'm not calling any witnesses. It's fair. It's their constitutional right. But if they don't address certain issues, that can result in a conviction. So really, it's fine. There is a right to remain silent, but if you have an onus to discharge, then you must place certain information before court. And I just want to highlight in the matter of Charlotte Botha versus the state that I've referred to, it's referenced in paragraph 35 of the state case of arguments, where the court pointed out that at page 32, when defense decides for whatever reason not to cooperate and not to disclose the defense or information which is needed by the court for purposes of adjudicating or on the bail application is not available. If that information is favorable to the accused, it stands to reason that the defense is at risk to prejudice the accused at the bail application hearing by withholding that information. So basically that's what happens. If they choose to withhold the information, well, it's their constitutional right, but it may prejudice them in the application at the end of the day, Your Lordship. Yes, Your Lordship, I think just to highlight on one last thing, thank you for allowing me to caucus. In this particular case, Your Lordship, we also respectfully submit that it will not be in the interest of the administration of justice and in public interest for the applicants to be released on bail when they have hidden from this court the existence of funds in Dubai, when it is known that they have funds in Dubai, Your Lordship, where they can start a new life. Can the court hear me, Your Lordship?
I hear you, but I'm worried whether, yeah.
Yes, Your Lordship. I think I just wanted to highlight that point, but for the rest of the issues, as I indicated, they are in the heads of arguments. We've addressed all the other issues in the heads of arguments, unless there's anything else in particular that the court wants me to address. Those will be the state submissions, Your Lordship. Is it to the court?
Any reply on a point of law?
Lord, there are only points of law, sorry.
Yeah.
Lord, I just want to say that the issue, there were a number of factual issues that were debated, so I won't address them. But there are 2 points that I want to make, my Lord. The first is, the learned friend for the state says that, and as your Lordship pertinently placed on, asked my learned friend to respond, is it fair that 27 months later the accused remain in custody? We don't know how long, much longer it is going to be. My learned friend's answer, my Lord, is, and it is a worrying answer, it is, well, they have the onus because it's a bail application. My Lord, what my learned friend forgets is what the Constitution provides, and the constitutional right your Lordship is referring to. Lord, Article 12.1a makes the point that in the determination of their civil rights and obligations, any criminal charges against them, all persons shall be entitled to a fair and public trial. That's subparagraph A. And then subparagraph B says, a trial referred to in subarticle A shall take place within a reasonable time, failing which the accused shall be released. Now, it doesn't assist, my Lord, to say, but it's in the hands of the accused to determine the reasonableness of the period. The state is the prosecutor. It is dominus litis. It must say to your Lordship that we are ready, the trial will take place now. But in any case, 27 months have already passed. So to suggest that there is an onus on the accused is to misconstrue what the Constitution provides. Lord, there is one other point that I want to make, and it relates, my Lord, to an issue that your Lordship raised with me at the tail end of my address this morning. And it was this, my Lord, that is the fact that the accused did, or the applicants did not disclose information relating to the alleged money in Dubai, is that not an indication of interference with the administration of justice? And the example your Lordship gave to me was, well, if the Dubai authorities are not cooperating, isn't that an interference with the administration of justice. Lord, Your Lordship raises a very pertinent point, and that I can't dispute, and I conceded that this morning. But having given the matter further reflection, my Lord, the fact that Dubai does not cooperate can't be placed, with respect, my Lord, at the doorstep of the accused, as if they are the ones who are impeding the cooperation. I'll give this example, my Lord. If, for example, there was an application by the Namibian authorities to the authorities in Dubai, and the authorities in Dubai said to the applicants, do you have any representations to make? And they had then volunteered that they didn't want this information. That one can understand. I only make the point, my Lord, that it can't be held...
Objection, Your Lordship. What is the legal issue being addressed? I have not heard the court give permission to address any factual issues. As it please the court.
So the legal issue is what constitutes interference.
As it please the court, Your Lordship.
And my Lord, it's a matter that was debated this morning. I was just expanding on the point I made as to whether it would constitute interference with justice on the part of the accused. And the point really, my Lord, is it might be impeding the administration of justice, but not as actions of the accused. That's the only other point I want to make.
Mr. Patela?
Yes. But I will just be brief, maybe a minute or so. This relates to the submission on the issue of new facts, which I want to just buttress following the contentions by my learned friend. My Lord, of course there is the contention that there is a possibility or there is a likelihood of interference. That also came to the fore. I just want to clarify that likelihood, my Lord, is on a higher level than guesswork, conjecture or suspicion or speculation. Likelihood, the way I understand it, it denotes that there must be a probability based on certain objective facts that have been placed before the court. I haven't seen those facts being preferred, neither in the heads of our learned friend or in the contentions that they were raised with the court of the likelihood of interference. Likelihood, my Lord, I submit that is on a different footing than what our learned friends conclude, which I believe would fall under the rubric of guesswork, conjecture, or speculation. As a result of which, my Lord, I submit that, and now I'm going to the issue of, the determination of the appropriate basis of new facts. Once they have been established, the court has no limitations in terms of considering the evidence before it and looking at that compendium of all the facts that are before it and making a determination whether the accused or the applicant is entitled to bail at that stage or not. And as a result of which, my Lord, I'm still very confident in my submission that once we have established those new facts as we have established, and I suggest that they remain unchallenged, the court is at liberty to consider this bail application, my Lord, as it should. That is the only response that I can give at this stage, on those two grounds, my Lord, as it pleases you.
Rest of our case is nothing at law on reply.
Okay. Thank you. Now it's my time. Yeah. We have made a commitment. We have agreed that I must deliver judgment by the 1st of April. And in hindsight now, when you think about it, I ask myself, why did we choose the 1st of April? Whom are we going to fool on that day? Yes. I hope newspapers, it won't be an April Fool Day. It will be a judgment. So The matter is postponed to the 1st of April for delivery of judgment.
As it is reported,
As the
Lordship.
court pleases.
Lord, may I take this opportunity on behalf, I speak on behalf of all the council, to thank you for your patience throughout this very lengthy, it is a lengthy band application, and I think you've been most patient with all of us, and on behalf of all my colleagues, I wish to thank you.
We echo the same sentiments, my lord.
Thank you.
Yes. I'll thank you in the judgment.
As it pleases you, my lord.
Thank you. Go to rise, and then the matter is adjourned until the 1st of April.